Think about this. It's the early morning in January 2026 in Washington. From California's district courts to from the appellate panels in New York, the Supreme Court's marble halls to overwhelmed clerk's offices in several different jurisdictions. Something that has never happened before is happening. Lawyers are filing briefs at a fast pace. Never before in the history of the United States. Judges are giving out emergency orders. Scholars of the Constitution are working trying to figure things out all night. Many legal questions that have never been asked tried. The stats alone tell a narrative that should make you stop. As of the beginning of January 2026, more than 583 people have sued to challenge things the Trump administration did government. Not 583 lawsuits in 4 years, but 583 lawsuits in only a year. To say that, to put things in perspective, at President Obama's for the whole 8 years he was in office, 160 lawsuits were filed against him. Policies of the administration. During all of Trump's first term, there were about 300 cases filed. We're now seeing that amount quadruple in 1 year. But this is what sets this apart from any other administration, from any earlier point in the history of the Constitution. Not only is it the number, it's what these cases show. They're not debates over policy as legal reasoning. They are basic questions about whether the president can just ignore the limits that have held back executive power since the beginning of the republic. Let me show you around what's really going on, since the headlines don't show how big of a deal this time. That entity we call the Supreme Court, think of as slow, careful, and planned and measured, is dealing with something it has for the first time ever. Many urgent questions concerning the power of the president, arriving at the same time, all asking for solutions that will shape the office for years to come. And this is what you should be worried about. Every American, no matter what their political affiliation. The judges realize that their decisions in these incidents won't only have an effect on Donald Trump. It will set standards that every future president, whether they are a Democrat or a Republican, will be able to call. As you're reading this right now, the Supreme Court is getting ready to make a decision about 3 situations that legal experts are identifying the most important tests of presidential power since Watergate. Let me show you each one because the details are more important than the drama. First, there's the right to be born case of citizenship. On the 20th of January 2025, he was back in office for the first time on Trump's first day, signed an executive order that tried to stop giving kids automatic citizenship born in the U.S. to parents who are here without permission or for a short time. Think about what that means for a moment. The 14th Amendment was passed in 1868 after the Civil War, states clearly all those who were born or naturalized in the U.S. and pursuant to its jurisdiction are citizens of the United States. That the language was written to change one of the most embarrassing things the Supreme Court has ever done decisions, like the Dred Scott decision, said that Black Americans may never be citizens. That amendment has been in place for 157 years, understood to give citizenship to almost everyone born in the U.S. dirt, with only a few small exceptions for kids of ambassadors from other countries or armies that invade. Trump's order from the White House says that kids of people who are in the country, illegally immigrants, are not required to follow the United States authority. And so they don't meet the requirements for citizenship. Legal professionals from both sides of the political spectrum. People on all sides of the political spectrum have labeled this interpretation unprecedented against the law and against more than 100 years of law that has been in place. The Supreme Court of 1898 case, Wonka-Mark versus United States, specifically answered this question, saying that a child born in San Chinese immigrant parents in Francisco was a citizen of the United States, even though his parents not being able to become citizens themselves under the racist laws of that time. But this is where it gets interesting from a legal point of view, and harmful in a constitutional way. Every single federal judge who has looked into Trump's right to citizenship by birth, the order has said that it is not constitutional. Not some judges, not most judges, but all one by one. District courts in New Maryland, Washington, and Hampshire, all of California, has stopped the policy. The 9th Circuit Court of Appeals, in the detailed decision, said that the order breaks the Constitution's plain text. But the Supreme Court nonetheless consented to hear the matter, setting a date for oral arguments between February and April at some point 2026, with a decision due by the end of June. What does the timing matter? Because June 2026 is only a few months away, the election's in the middle of the term that will decide whether Trump stays a politically viable force or becomes into president who is lame duck. The conservative side of the Supreme Court, the majority could have stopped this right away, could have just said this policy is clear in the Constitution, can't stand. Instead, they're letting it drag on, letting the not knowing keep forward, letting the law and people, the effects build up. Some people who observe the courts think the delay is strategy, that the justices want Trump weakened before they give him a big failure. Some people are worried that it means anything. Darker, that the conservative majority is thinking about rewriting constitutional law that has been around, not contested for more than 100 years. Let's talk about tariffs now, because this situation might be even more important than birthright being a citizen. In what Trump has dubbed his freedom, the administration said that day tariffs were a national emergency and put in place hefty taxes on goods from dozens of list countries utilizing a statute from 1977 called the International Economic Powers in Times of Emergency Due. The objective of that law was to help real emergencies or times when an immediate threat to national security necessitates the president must act right away. The Congress. It has been used to freeze the assets of terrorist groups, to punish bad countries with penalties, to respond to real emergencies. Trump is using it to change trade policy around the world and impose tariffs that could hurt American more than corporations and consumers, 100 billion. And this is the important question about the Constitution. Does the president can do it alone power to do this kind of thing, economic policy, without Congresses? Do you agree? The Constitution's Article 1, Section 8 provides Congress, not the president, the ability to control trade with other countries' nations and to set and collect taxes, duties, and excises. During oral argument in November 2025, even the justices of the Supreme Court who are conservative seemed doubtful. Judge Amy Coney Barrett asked if the emergency, the law gives the president such a wide power in the economy. Justice Brett Kavanaugh asked direct issues concerning the constraints on the power of the president. If the court doesn't agree with Trump, the government would have to give back money, billions in tariffs that have already been paid, and Trump's main economic policy would fall apart in a day. If the court agrees with Trump, it would change the balance of power at its core between the president and Congress on trade problems, which will give future presidents an unparalleled amount of power to make one-sided choices about the economy that impact every American's finances. A decision in this scenario could happen any day soon. The justices heard arguments for more than 2 months ago. They've had time to write what you think. Court watchers are checking the Scottish blog every day, waiting for the choice that could change the course of events. For decades, American economic policy has been. And then there's the Federal Reserve situation, which may seem technical but has huge effects. Trump tried to terminate Lisa Cook, a part of the Federal Reserve Board of Governors, said she was inconsistent with the rules of my administration. The federal law, specifically the Reserve Act, stipulates that governors can only for a good reason, which means proved wrongdoing or inability, not debates on policy. The whole idea of how the Fed is set up aimed to keep monetary policy separate from political pressure, to stop presidents from changing interest rates for short-term political gain at rates for short-term political advantage at the cost of long-term economic stability. Trump's stance is extreme. He says that all branches of the executive branch officials, even those at the Fed and other independent agencies, Federal Trade Commission, and the SEC or Securities and Exchange Commission, serve at the president's will and can be let go for any cause or none at all. If the Supreme Court agrees, same point of view, and during oral arguments in December, a number of conservative, it felt like the justices were going to do it, would go against a rule that has been in place for 90 years and put presidents in charge of agencies that keep an eye on everything from stock markets to interest rates to mergers of businesses. Think about what that means in real life. A president might fire Fed workers who won't cut interest rates before an election, The president could fire FTC commissioners who aim to stop mergers that involve the political friends of the president. The president might fire SEC officials who look at companies that give money to the president's campaigns. The whole framework of independent regulating agencies grew over for decades. To stop this kind of thing from political meddling would fail. These three cases alone, birthright citizenship, tariffs, and the federal conserve autonomy, exemplify the utmost biggest growth of presidential power authority tried by any government in the history of the United States in the present day. But they're not taking place on their own. They're part of a bigger pattern that has lawyers using words they don't know use with care. A constitutional crisis. Please let me be very clear about what that means, that there is a constitutional crisis word that gets thrown around a lot in a relaxed way. It doesn't mean the president is doing things that people don't like. It doesn't mean that policies aren't popular. It means the basic ways that stop tyranny, the splitting of the independence of the courts and the separation of powers. The rule of law is being put to the test in ways they haven't been since the Civil War or Watergate. This is what's really going on the ground. And a lot of times in 2025, federal judges told to stop doing what the Trump administration says something. And the government found creative ways to not follow the rules, not through appeals, which would be completely legal, through what legal scholars refer to as non-compliance with the law, using technical explanations and procedural arguments to mask the fact that people are not following court orders. The most famous example was Aquilmar Abrego is a man from Maryland, Garcia. Immigration officials made a mistake, sent him back to El Salvador, which is one of the most dangerous places in the world, has a prison system so harsh that violates human rights and other countries' standards. A judge from the federal government told the government to bring him back. The administration asked higher courts to help. Courts lost at every level, and finally the Supreme Court itself said the administration must facilitate Abrego Garcia's return. The administration's response, they argued that facilitate doesn't mean actually bringing him back, just making some gestures toward encouraging El Salvador to release him. Legal experts across the spectrum said that interpretation was absurd, that the administration was openly defying the Supreme Court. As of early 2026, Abrego Garcia remains in El Salvador, and the administration continues to argue it has complied with court orders. In another case, Judge James Boasberg in Washington, D.C. issued an emergency order stopping deportation flights of Venezuelan migrants to El Salvador. The flights continued anyway. The administration later argued the planes were already over international waters when the order came through, even though evidence suggested otherwise. Judge Boasberg found probable cause to hold the administration in contempt of court. In Rhode Island, a federal judge explicitly stated that the Trump administration defied a temporary restraining order by continuing to freeze federal funds the judge had ordered released. The administration appealed, which is their right, but in the meantime, the funds remained frozen in apparent violation of a direct court order. Multiple legal scholars, including professors at Columbia, Georgetown, Rutgers, and NYU law schools, have said publicly that these actions constitute a constitutional crisis. University of Virginia law professor Amanda Frost put it this way: "We're not yet in a full constitutional crisis, but we're undergoing a constitutional stress test, and the question is whether the courts and Congress will have the will to stop executive overreach." Chief Justice John Roberts, who almost never comments publicly on political matters, gave a speech in September 2025 in which he warned about 4 threats to judicial independence: violence, intimidation, disinformation, and threats to defy lawfully entered judgments. That last one, threats to defy court orders, was directed squarely at the Trump administration. When the Chief Justice of the United States feels compelled to remind the president that court orders must be followed, that's a 5-alarm fire for the rule of law. Vice President J.D. Vance openly questioned judicial authority on social media, posting, "Judges aren't allowed to control the executive's legitimate power." Trump himself said a judge who ruled against him shouldn't, frankly, be allowed to make that kind of decision. These aren't off-the-cuff comments. They're testing whether the public will accept the idea that presidents can ignore courts they disagree with. Now, let me put this in historical context, because Americans have faced threats to constitutional government before. During Watergate, Richard Nixon tried to claim executive privilege to hide evidence of crimes. The Supreme Court ruled unanimously against him, and Nixon resigned rather than face certain impeachment and conviction. Nixon never openly defied a court order. He resigned. During the Civil War, President Lincoln suspended habeas corpus, which allowed military detention without trial. That was challenged in court, and there was tension between Lincoln and the judiciary. But even in the middle of an existential war, Lincoln never claimed courts had no power to constrain him. During the early days of the Republic in Mary vs. Madison, President Jefferson's administration simply didn't show up to defend itself at the Supreme Court. Chief Justice John Marshall faced a dilemma. If he issued an order Jefferson would ignore, it would reveal the court's weakness. So Marshall wrote a brilliant opinion that established the court's power of judicial review while cleverly avoiding giving Jefferson any order to defy. The crisis was avoided through judicial craftsmanship, not executive compliance. What we're seeing now is different. The Trump administration isn't avoiding court showdowns. It's seeking them out, testing whether courts can actually enforce their orders, probing whether the political environment has changed enough that presidents can get away with ignoring judges. And here's what makes this moment particularly dangerous. During Watergate, Republicans eventually turned on Nixon. Barry Goldwater, Hugh Scott, and John Rhodes walked into the Oval Office and told Nixon he'd lost Republican support in Congress. That's what ended the crisis. Right now, most congressional Republicans either support Trump's challenges to judicial authority or stay silent. Without Congress willing to check the executive branch, courts are left trying to enforce their orders with limited tools. What tools do courts actually have? They can hold officials in contempt, which can mean fines or even jail time. But who enforces contempt orders? The U.S. Marshal Service, which is part of the Justice Department, which is controlled by the president. You see the problem? They can impose increasingly severe financial penalties. They can issue more detailed orders. They can point to professionals in charge of discipline or criminal prosecution. But all of these fixes assume the executive branch will work together at some level with its own responsibility. What happens if it doesn't? That's the question about the Constitution that's being tested right now in real time in dozens in courtrooms all over the United States. And it's not just Trump. It's about if the next president, whether they are a Democrat or a Republican, will take over a system where court orders are more like suggestions than orders, where power is in charge limited only by political will instead of legal limits, the Supreme Court. The court seems to get what's at stake, which explains why it moves so carefully all of 2025. The justices mostly stayed away from direct fighting with Trump, giving him wins in technical procedural grounds while pushing substantive choices until 2026. They've been smart and waited until Trump's ratings went down. He had about 48% approval at the start of 2025, finished at about 42%, before making plans for arguments in the cases most likely to lose for the government. But that plan has its own problems. Every delay lets Trump set precedents to make practices normal that presidents before this one wouldn't have tried. Every procedural win, even if ultimately reversed, it shows that strong claims of executive power can work, at least for a while. And time spent in court fighting is time not spent on government, time not used dealing with real problems that real people from the United States. Let me bring this back to what it means for people who are watching at home. Because constitutional law can feel like you're not really there when you're worried about prices at the grocery store and job security. But here's the deal. Stable government and rules that are easy to understand, working institutions. These aren't extras. They are the base that makes everyday life feasible. When presidents can set tariffs by executive order without the approval of Congress, businesses can't plan or supply without approval. When chains break, prices go up, not able to be predicted. When birthright citizenship changes uncertain, millions of families are stuck in legal limbo and unable to make plans for the futures of their kids. When regulatory agencies are not part of the government, lose their independence, the money policy becomes a political issue, the economy becomes less stable as markets. everyone has a harder time making plans. And when courts can't do this, limit what the executive can do, everyone becomes weak. It could be today deporting immigrants, even though the court said so commands. It could be reporters tomorrow taking away their licenses, political people who are against them being investigated, activists losing their permits to protest. Once the principle is made it clear that presidents can ignore judges they don't agree with, there's no limiting principle. Every future, the president will feel free to go more. This is why the next few months mean so much. The Supreme Court will probably make a decision about tariffs in February. They'll choose birthright citizenship by June. They'll give their thoughts on independence of the Federal Reserve soon after. Lower courts will keep dealing with contempt cases with ways to make sure that the most important question of whether their orders mean something. And Congress, although it has been mostly quiet so far, it could still make a case for itself. The strength of the purse, the power of oversight, and the power of impeachment. These tools are real. They need political will to use, but they are there. We're at a turning point. No, because Donald Trump is one of a kind threatening, even though what he does is unprecedented, but only because the constitutional system was made for exactly like this. The people who wrote the Constitution knew that leaders with big dreams would come along who thought power was something they owned instead of public trust. They constructed in checks and balances and the division of powers, a court system that is not connected to the government specifically for this situation. The question we're answering right now through these 583 lawsuits and more, through oral arguments in the Supreme Court and contempt hearings in the district court, through the daily hard work of lawyers, judges, and clerks all over the federal system, is if those constitutional mechanisms still function, if the parchment walls Madison wrote about in Federalist 48 can actually limit a determined executive in a time of division politics and loyalty to one's tribe. People will remember 2025 and 2026 in the future as a turning point. The courts are held, Congress reestablished itself, and the rule of law stayed in place, or there were precedents that changed the way things were done, changed the balance of power in the U.S. government, putting power in the hands of the presidency in ways that the founders would have seen as royal. We won't know which way we're going until the Supreme Court makes its decisions in the next few months, until we find out if judges can make sure their orders are followed without working together with the executive, until we find out if Congress will do anything to protect its own constitutional prerogatives or keep putting off power of the executive. But we do know this right now. There really is a legal avalanche. It's never seen before in terms of size and scope. It stands for basic questions about American democracy that we believed were settled a long time ago. And the answers we get will affect what kind of country we live in, what kind of power the government has. Presidents in the future will be able to use. If you thought this deep dive was useful, understanding how the mechanics work behind the if headlines are important to you, think about signing up. We're going to stay on this story as it unfolds, breaking it down. When the Supreme Court gives its opinions, issued explaining what it means to be in contempt, what proceedings really mean, tracking which precedents are still in effect and which ones crack. This is the story of our time, and it needs more than sound bites and anger. It needs to be clear-headed, analyzing what's really at stake. So please let me know in the comments if you believe the Supreme Court will decide against Trump on tariffs and birthright. What is citizenship? Do you think courts can do a good job of carry out orders against a determined executive? And most importantly, what do you think it means for the country if they can't? Because that talk, that coming to terms with reality instead of rhetoric, is where understanding really happens. Starts.